Thank you. Dr. Staker, you have the floor.
Madam President, members of the Grand Chamber, I address Articles 7, 8, and 11. As to Article 7, the applicant was convicted of a crime expressly provided for in Article 314 of the Criminal Code and Articles 1, 3, and 5 of the Anti-Terror Law, which had existed in their present form for many years. These provisions make mere membership of an armed terrorist organization a crime. This is in itself inherently criminally reprehensible conduct. The legislation does not and need not make criminal liability dependent on the actual commission of crimes by the organization. Criminal liability is not made dependent on the existence of a prior judicial decision declaring the organization terrorist. Being a member of such an organization is criminal, even if the authorities do not yet even know that it exists. The lack of such judicial decisions before October 2015 is thus immaterial. The Court of Cassation's acquittal of Fethullah Gulen in 2008 is also immaterial. That case concerned evidence and events up to 2000. It did and could not determine what that organization would be in 2015. The agent for Türkiye has referred to arrest warrants for Fethullah Gulen and press reports predating the applicant's use of bylock referring to FETÖ as an armed terrorist organization. By the time of the applicant's trial, there were judicial decisions declaring the organization to be terrorist. The applicant's indictment refers to a decision of the Erzincan Assize Court. In his subsequent proceedings, the Kayseri Assize Court referred to judgments of the Tokat Assize Court and the Samsun Regional Court of Appeal, while the Ankara Regional Court of Appeal relied on decisions of the Court of Cassation in the Basha and Özçelik case. This case is therefore different to Parmak and Bakir versus Turkey, where the court spoke about what domestic courts must do when confronted with the task of assessing for the first time whether an organization can be classified as terrorist. That is not the situation here. The Regional Court of Appeal found, based on earlier case law, that the organization's purpose was to take control of the country by force if necessary. It must have been reasonably foreseeable to anyone in October 2015 that an organization with those purposes would be an armed terrorist organization for purposes of the legislation. This crime has a specific mental element, or mens rea. The applicant was required to know the purpose of the organization. This was expressly acknowledged by the Ankara Regional Court of Appeal, which found that the applicant had that intent. The finding that the applicant had this intent was for the domestic court. As Professor Talman has submitted, This court is not a fourth instance and will not deal with alleged errors of fact by domestic courts unless they were manifestly arbitrary. They were not. The applicant was not punished for using bylock, nor was he punished for depositing money with Bank Asia or for being a member of a trade union and association. He was convicted of membership of an armed terrorist organization, namely FETÖ. His use of bylock and other activities were merely evidence of his membership of FETÖ. If a person is convicted of murder on the basis that their DNA evidence was found at the crime scene, they are not being punished for leaving DNA evidence. Here, bylock use and the other activities are like the DNA evidence. The convention question is whether the applicant could reasonably have foreseen at the material time that his membership of the organization would make him criminally liable, and not whether he could have reasonably foreseen the evidence or circumstances that might be used to prove that membership. As to Article 8, the bylock raw data was first obtained by the National Intelligence Organization pursuant to Law Number 2937. It was obtained in accordance with the law. The evidence shows that the National Intelligence Organization, MIT, acquired some 109 gigabytes of bylock raw data located outside Turkey. 109 gigabytes is about 1/10 of the capacity of a modern 1 terabyte laptop. This is not bulk data interception defined in Big Brother Watch as huge volumes of data. The raw data was encrypted and unreadable, and its contents were unknown. This was not a case of ongoing secret surveillance measures as generally understood. Any interference with Article 8 rights at that point, if any, was a minor interference and was justified under paragraph 2 of Article 8 in the interests of national security. Furthermore, on 9 December 2016, a judicial order authorized the analysis of the raw data for criminal justice purposes. The government says that the 9 February 2017 bylock findings report was based on information extracted from the raw data pursuant to this judicial order. The Ankara Regional Court of Appeal said that the conviction was based on the internet and telephone records, the bylock findings report, and the expert report. The bylock findings report, as I've just indicated, was obtained pursuant to judicial order. As to the phone and internet records, by law, these are given by the private service provider to the Independent Information and Communications Technologies Authority, the BTK, which provided them to the court pursuant to a court order under the Criminal Procedure Code. The law on how long the data could be kept applies to the service provider, not BTK. Furthermore, even if BTK had been subject to the time limit and had exceeded it, this would not mean that it would violate Article 8 for the court to receive that material pursuant to a court order and use it. As to Article 11, the government's reading of the judgments of the Assize Court and Regional Court of Appeal is that the applicant was not convicted for having been a member of the trade union or the association. These memberships were merely circumstances that the domestic courts took into account when determining whether he was a member of FETÖ. The domestic courts were not penalising him for having been a member of the other organisations, and accordingly, no issue arises under Article 11. For these reasons, no violations of Articles 7, 8 and 11 are established. Madam President, members of the Grand Chamber, that concludes the first round of oral observations of the Republic of Turkey. I thank you for your kind attention.
Thank you for your submissions.